Very good, thank you. I'd like to call this session of the Boardroom Division to order and acknowledge that we are in Treaty 1 territory, the home and traditional lands of the Ojibwe, Cree, and Dakota people, and the national homeland of the River Métis. Our drinking water comes from Shoal Lake 40 First Nation Treaty 3 territory. With me today are Mike Colachuclio and Kira Panner. My name is Harvey Diamond, and I will be chairing this panel. The Winnipeg Assessment Department is being represented by Stephen Lobenstein, and our administrator is Phoebe Graywood. We will be hearing an application revision of the assessment rules in accordance with the Municipal Assessment Act. The matter for which revision is requested has been described in the application that we will be dealing with today, and we will limit discussion to those matters. The statements made at this hearing must be sworn testimony. Anyone speaking to those matters will first be sworn in. Be advised that comparisons of assessments of property is not considered as evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City Administration. It makes its decision based on the evidence provided at the hearing and issues a written order that will be mailed to all parties as soon as possible. And please note that the board's decision with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or to classification, or to the Court of King's Bench if the matter pertains to an application for exemption from taxation. And should you wish to appeal, information on how to do so will be included with the board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each applicant following their swearing in. We will then have the assessor's testimony followed by any questions the applicant may have, and the applicant's testimony followed by any questions. Each party will be given an opportunity to summarize the wish to do so. Once all the evidence upon the application is brought forward, that may leave, the process will repeat for each item on the docket today. The session will close after the applications have been heard, and the board will deliver them in private to make its decisions. And you'll receive the board's order by pushing the mail as soon as possible. We have one item remaining on the docket today, which is item number 1 on the docket. And Ms. Graywood, can you please affirm the assessor and the applicant's testimony at this time?
Mr. Lobenstein, can you state your full name?
Stephen Lobenstein.
Do you affirm the evidence you're about to give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Powell, can you state your full name?
Scott Powell.
Do you affirm the evidence you're about to give at this hearing is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay, the matter that we have today is the property that is located at 310 Sterling Lion Parkway. And I note, Mr. Powell, that you have both classification as well as assessed value as points of appeal. Are you proceeding with classification, or is that a mistake?
Assessed value, and we do have a preliminary matter as well, Mr. Chairman.
Which we'll discuss in a minute, but are you pursuing classification as well?
No.
Okay, so you have to withdraw that. There's a formal withdrawal.
I will formally withdraw that.
On that basis, and yeah, you'll have to sign a formal withdrawal, which...
I'll send you a form fairly.
Okay, and I know you have a preliminary matter, which, because I've read over the material, and so Mr. Powell, I'll let you proceed with your preliminary summation if you wish to.
Thank you, Mr. Chairman. Thank you, board members. With respect to the subject property, the annual assessment for which this hearing was scheduled was concluded as a value of $17,589,000. It's predicated on a property comprising 136,000 square feet. There was a supplemental assessment issued to a revised value of $22,414,000 on a revised site area for the property of 164,657 square feet. Ryan, from whom I am representing, was not notified of the supplementary assessment notice until engaging in direct discussions with the assessor on August 26, 2024. The property owner was also not aware of the change. Ryan ULC submitted a formal request to the Board of Revision to move the appeal and filing fee to the revised assessment of value, and that was declined. The originating application was filed on July 19th, and the revised assessment notice was mailed on July 16th. In accordance with the Supreme Court of Canada 2002-156, Documents served by ordinary mail are deemed received after the 5th business day. And as a result, the supplementary assessment was received after the filing of the originating application for this hearing. This creates a situation whereby the complainant is disadvantaged with respect to, 1, what are the values and details under complaint today? 2, what is the jurisdiction of the board to rule such that it supersedes the revision of the value? And 3, what is the jurisdiction of the board to hear and rule on the grounds of complaint? Based on the discussions with a representative from the Board of Revision on September 23, the appeal in the hearing that we are having today is moot, and the board has no authority to provide remedy through assessment appeals that would reside within the board's jurisdiction. Ryan ULC, on behalf of the respondent, takes the position that 1, the act of revising an assessment under complaint, identified as a procedural principle. 2, the inability of the Board of Revision to, should it deem necessary, grant remedy, which stands as jurisdictional principle. And 3, the act outside of a complainant's control nullifying an appeal fee of $610. All 3 would constitute a violation of the duty of fairness and the principle of natural justice. With respect to this, in summary, the city of Winnipeg did nothing wrong. They have the right to issue supplementary assessments, and it was not malicious or outside of their powers to do so. Conversely, no act has been taken by the assessment person which supports the loss of their appeal rights, the right to have their hearing heard by an agent which can grant remedy, nor their complaint fee. As a test of reasonableness, neither party should be penalized for their actions. Based on this, we seek the board's guidance in terms of how we proceed with this matter. Thank you.
Thank you. Mr. Lobenstein, is there anything that you wish to add at this time or question?
No, that was summed up well. I have nothing to question on that. In terms of adding it, I'll just say, yeah, there was an addition to this building. We added the addition to the roll. We sent out the supplementary notice on June 20, or it was effective June 28th, 2024. And I believe we mailed it on July 16th, 2024. So there is a supplementary notice. There is a new value to this property, which does make the appeal for the original value of $17,589 moot. So that's all I have to say.
Okay, Ms. Petter, any questions of the applicant?
No, thank you.
Mr. Kolchukli, do you have any questions?
Just to be clear, you're suggesting that both the owner and yourselves, as the agent for the owner, were not notified of the supplemental coming through?
That is correct. What I should have added, and should I say that Mr. Lobenstein and I have had a lot of good conversations over the past few weeks, and we have tried to, between our respective selves, find a route forward to clarify and solve this problem. We just haven't been able to. And the first we heard of it was through discussions after the appeal was filed, at which point we realized the value had changed. We looked to the Board of Revision for guidance and support. We don't know how to proceed or what values under complaint, as we've discussed.
So subsequent to those comments, Mr. Powell, I was hoping that you could inform us that both the owner and yourselves have since received the supplemental.
Yeah.
Do you know why that may have been delayed in coming your direction, sir?
GFS is a large international organization located in the United States. The receipt through international borders to them, through their mail group, through their contacts with Property Management for Canada to us. They are very savvy and they understand that flagging this information for us. They didn't see it. We didn't see it, but they did get it after the conversations where we identified this issue in late August.
So, Mr. Powell, could you tell us when they received that notice? Surely they would have that date stamped.
They would. I don't have it. I just got a copy of the electronic notice
Fair enough.
And that was after talking with the assessor and realizing we needed to do some digging to find this. And a few days later, they did receive it. But they didn't have a date stamp on it, so I do apologize.
Okay, Mr. Lovenstein, as far as the department is concerned, you had mentioned that the original sup was June 28th, correct?
Correct.
And that the notice would have been sent out in July sometime,
Yeah, July 16th, I believe, is the date when it was sent.
so July 16th. So, to your knowledge, just refresh mine, it's been a while for me, but how long do they have for appealing on a supplemental? Is it still 30 days?
No, under the Municipal Assessment Act 14.3, it is 20 days.
20 days?
Mhm.
Do you have any other questions, Mr. Colachuglio?
I think those are my questions for the moment. Thank you.
Thank you. So, Mr. Powell, you're asking us for advice, and we're not really in the business of giving advice. We hear assessment applications for reductions, and that's where we're limited to, and we don't have the jurisdiction to grant relief that a court could grant. We're just we have to go by the procedures that govern our board. So we don't have, even if we wanted to assist you, we don't have the power to do so unless you can show me somewhere where we do.
Great question. One would be, even if we went through this hearing and this board ruled that the assessed value was incorrect, my question back would be, would that value supersede the supplementary value?
We would hear it. Yeah, unless we have jurisdiction, I wouldn't even be able to hear it, unfortunately.
So then this board doesn't have jurisdiction to hear the hearing, even though they
we have
received the
jurisdiction to hear the hearing
complaint.
on the basis of the matter before the supplementary, which you filed an application on, and we definitely can hear that. That's before us. We can't deal with the supplemental.
Right.
As far as that's my position. I'm asking you.
Okay.
I mean, I'm gonna have
the only
to.
thing that I could identify, and when I meant the word advice, I was looking for guidance as opposed to advice. However, what I will say is in the Manitoba Municipal Assessment Act, Section 63-4 does allow the board to direct the assessment be redone. So I do wonder if the board can ask that the assessment be redone to the exact value of the supplemental, allowing us to file a complaint and move the $610 cost over. The issue we have is that the taxpayer has paid funds to have a hearing in front of a board that can grant remedy should it deem so.
Okay.
If this is moot, the client not only loses their money, but they lose the ability to have that heard. And I don't see that as procedurally appropriate.
Well, no, you still can. You filed on the basis of the original assessed value, and that still can go ahead. And we're prepared to hear that. No, we're prepared to hear that today. The supplemental would be the increase on the new portion. Which
it's not the increase on the new portion; it's the revision of the entire assessment.
I understand.
So this board could rule, and it would supersede the supplemental value, because in my discussions with the assessor, the verbiage that we received was that no matter what this board does, it cannot supersede the $22,414,000.
And that very well might be the case, in which case there's,
Yeah, there's been a new value put out.
Yeah.
Been a change. There's been a physical change to the building. The building is not the same as it was when it was originally appealed. So that value will stay. That value can't be changed.
Okay.
So the board can't change the assessment, which brings us back to the originating point, which is this board can't grant remedy.
Okay.
Which is one of the fundamentals of natural justice.
Okay, that's we will go into camera and we'll discuss
Thank
this.
you.
We'll let you know where we stand.
Thank you.
Okay, we've gone and deliberated on this matter, Mr. Powell, and unfortunately, though we have sympathy for the plight of the applicant here and your client, we have no jurisdiction whatsoever to grant any of the relief you asked for. We have before us today an application on the original assessment, and that's all we have. And any decision that we make on it will be moot, as you indicated, because it's supplanted by the supplemental that has not been appealed and is not before us today. So that no matter what decision we make, will not change anything. But we do have your application before us, and we will hear evidence, unless you want to simply, to make matters easier, agree to confirm the assessment, which we can do on your request to do so. Otherwise, we'll hear you on the basis of your original application only. But as I said, any decision we make will be moot because that assessment is no longer the assessed value of the property. You will have an opportunity to make an application for 2025, which you can do when the 2025 applications are open for assessment reduction applications, but that won't be till next year.
May I ask one follow-up question, Mr. Chairman?
Absolutely.
With respect to the fact that this hearing is moot, does that also mean that the taxpayer loses their appeal fee?
I believe it does. But that's something you'd have to take up with administration. That's not something that we deal with as a board. We deal with tax assessments, and we either keep them, maintain them where they are, increase them when there's an application to do so, or reduce them when we feel that it's fair to do so. And that's basically our role. So I'm not going to tell you, and I'm not going to make a ruling on that regard. I don't have the power to do so. You can discuss that with administration if you wish to do so.
Okay, well, let's proceed. Thank you.
Okay, we can proceed then. So we're proceeding on your original application then. And so then, Mr. Livingston, you can proceed then when you're ready. And I know that the material you filed before us appears to have the USS value, so you'll have to do some arithmetic.
Sure, just give me a moment. Okay, I'll read in the roll number. It is 10006417600 Sterling Line Parkway. The value at appeal right now is $17,589,000. The effective years built for this property is 2006, and the wall height is 33 feet. The zoning's M2. We have a total land area of 997,963 square feet. And I believe we have a land to plan of 6.58. So going to my page 3, you can see the rent comparables. We have buildings ranging from 81,000 square feet all the way up to 148,000 square feet, with rents that range from $9 or $8.39 all the way up to $9.55. You can see the lease terms start from 2012 up to 2022, and they range from 1 year to 10 years. So this workup I will read out will be different than what's on my page. So the leasable area would be 136,316 square feet. We have a potential rent of $1,213,212, and that would work out to $8.90 per square foot. We have a vacancy of 4.5%. We are applying expenses of 3%. And we have a net income of $999,321. And we're using a 6.25% cap rate to apply to that NOI to get an estimated market value of, or an assessed value of $17,589,000. Working further, yeah, and that's just working further down my brief. You can just see in the addenda the location of the properties on Sterling Loin. It's on page 8, and you can see some exterior photos of the pictures on my page 9 and my 10. Thank you very much. It's my presentation.
Thank you. Any questions, Mr. Powell?
None, Mr. Chairman. Thank you very much.
Thank you. Ms. Penner, do you have any questions?
No questions for me. Thank you.
Mr. Kolochukwu, do you have any questions?
No questions at this time, Mr. Chairman. Thank you.
Thank you. And I guess the only question I have that you didn't really touch on was the capitalization rate used. Can you further that information for us?
6.25%. If you look on my page 6, this is our model capitalization rate. It falls between the 20th and the 80th percentile. It's sort of in line with all of the outside sources you can see on my right column. So that's our capitalization rate.
Okay, and that would be, if you're looking at your tables there, industrial, would that be industrial A or industrial B?
We don't really categorize that, as you can see. I know we put them in there more for the outside sources that do that. Ours all range from 5.35 to 7.30 for the 20th to the 80th percentile.
Okay, so this building by the model then would come somewhere north of 20% and quite a bit under 80%.
That's correct. Yeah, it's kind of in the middle range of our cap rates.
Okay, thank you. I don't have any further questions. Okay, Mr. Powell, you can go forward with your evidence.
Thank you, Mr. Chairman. I'd like to start just to keep things moving fairly quickly here. At the end of the preliminary matter, which we've already discussed, speaking of the appeal merits, the subject property in the opinion of the taxpayer is assessed in excess of market value as evidenced by sales comparables for relevant comparable properties. Requested value is $16,494,000. The next page, we have 2 images of the subject property. I think we've probably all seen enough images of them. So let's move on to the following page. We have at the top of the page 2 iterations of the subject property, again, based on the initial assessment and the supplemental assessment. Rate per square foot ranging between $129 and $136 per square foot. 2 market sales were found. Both occurred March 2023. They were 112,000 square feet and 268,000 square feet. That brackets the subject property, which is between 136 and 164,000 square feet, very nicely. AYOC of 2,000, subject is 2006. Again, we're talking about modern comparables. Sale price per square foot between $104 and $121 per square foot. As a consequence, our request is $121 a square foot, which works out to $16,494,000 or $19,923,000 based on the supplemental. The information with regards to those sales comparables is provided on the subject pages from 7 all the way until page number 10 for your review, Mr. Chairman. Thank you very much.
Thank you. Any questions, Mr. Lubinstein?
No questions.
Ms. Penner, do you have any questions?
I just noticed on the sales comp summary that it indicates that it's part of a portfolio. Was the portfolio just the comparables? I mean, did the portfolio only include these 2 properties, or were there others included in?
There were others. They were dedicated sale prices, however. So each one was done on their individual basis, which is why you get $120 per square foot for one and $104. So what it was a purchase of 10 properties in total. Each one had its own appraisal valuation broken out. So we didn't get the big lump sum and try to figure out what they were. Yeah.
Thank you very much.
Mr. Kolochukwu, any questions?
No questions at this time, Mr. Chairman.
Okay. Your comparables are both in the Inkster Park industrial area, which is a different area than the subject property. Is there any reason why you didn't use comparables in the vicinity of the subject property?
Fantastic question, Mr. Chairman. A couple of reasons. First of all, when we look at large scale mega warehouses and distribution warehouses, the types of investors looking for those properties are not as identified with specific sectors of a city because we're dealing with a very small subset of the industrial market. The second one is that looking at the comparability of properties geographically is sometimes easier than looking at the comparability temporally. Having March 2023 sales on the open market gives us a much better idea of the market value of properties like this, which is why we stuck with these.
Okay, and the properties, you put a sale price, so each, although it was a purchase of 10 properties, they each had individual prices set forth for them?
Yes, they were individually appraised and allocated.
So then what you did, then you allocated the lease amounts of 121.60 to 104.54 merely by determining the price and doing the calculations to determine what it would take to make that using a 6.5% or 6.25% cap rate?
No, what I mean is that each property was purchased on its own with its own individual purchase price, but it was done all together in a transfer between two entities. So what I mean by allocated is that the purchase price of 1345 Redwood was 13,586,041. And there was no math that needed to be done to back that out of a larger portfolio purchase. We were able to find that, and this is how it's reported on the open market.
So how did you get the lease amounts though per square foot?
We're not using lease amounts per square foot. We're saying that the market value of properties like this are between $104 and $121 a square foot.
Okay, so you didn't use an income approach at all?
No, we're looking strictly at looking for the standard of value. The valuation approach is a secondary thing, and we think that the standard of value supersedes, and in this case, sales in March where you don't have to time adjust just provide a much better understanding.
Okay, because technically these type of properties are, for the assessment purposes, are always done on the income approach. Not as
in this jurisdiction, absolutely. Not universally. So I'm from Alberta originally. We use the sales comparison approach.
Yep.
That's not universal. What is that the standard of value is market value. So we always have to come back to what would a property be worth if it sold on the open market? And what we're saying here is sometimes the best way to know what something would sell for on the open market is to see what things sell for on the open market. The income approach is a way to get there, but ultimately we still have to validate whether the sales of open market transactions tell us whether an assessment is correct or not.
okay. Thank you very much. Do you have anything else to add before that's the evidence?
That's the evidence. Thank you, Mr. Chairman.
Okay, thank you. We'll deliberate on this. You'll receive our decision in due course, and thank you for your attendance, Mr. Powell. And Mr.
Thank
Lucas.
you. Have a great day, everybody. Thanks a lot.
Thank you so much.
Thank you.